The Supreme Court just dropped its order list, and every gun owner in this country needs to pay very close attention to what just happened. Because what happened today is not just a denial. It is not just the court saying they are not interested. What happened today is the Supreme Court allowing a dangerous framework to stand. A framework that could let the government regulate virtually any protected arm as long as they slap the word "shall issue permit" on it. And I want you to understand something before we go any further into this. This is not just about suppressors. This is not just about one man's case out of Louisiana. What happened on that order list today has the potential to ripple across every single Second Amendment challenge currently working its way through the federal court system. Every single one. Because here is what the Supreme Court just allowed to stand. A ruling out of the Fifth Circuit that essentially hands the government a blueprint, a roadmap. A legal framework they can now use to justify regulating protected arms, arms that are explicitly covered under the Second Amendment, simply by dressing up that regulation as a shall-issue licensing scheme. And the Supreme Court today looked at that framework, looked at that reasoning, and decided to walk away. So if you think this stops with suppressors, you are not paying attention to what the Fifth Circuit just got away with. You need to watch every second of this video, because the implications stretch far beyond one conviction in a federal court. This fight is just getting started, and you need to understand exactly what just happened, why it matters, and where the battlefield moves from here. Before we get into the full breakdown, I want to take a moment to thank the sponsor that makes this kind of in-depth legal coverage possible, and that is Attorneys on Retainer. When we are talking about the government coming after people for possession of firearm accessories, when we are talking about ATF raids, federal criminal charges, and potential prison time, you need more than just an opinion. You need actual legal protection backed by a real law firm. Attorneys on Retainer is backed by the Attorneys for Freedom law firm, and they are constantly expanding what they offer because they understand that self-defense does not end when the trigger pull ends. It continues into the courtroom. Right now, in honor of America's 250th anniversary, they are running a very special promotion. Use code ARMSCHOLAR at sign-up, and you get $50 off an individual plan or $25 off a family plan. That is real protection from real attorneys, not some insurance product that might or might not pay out. Link is in the description. And given everything we are about to talk about today, given the legal landscape that just shifted beneath your feet, having actual legal protection in your corner has never been more important than it is right now. Now let us get into this. To fully understand the weight of what just happened today, we need to go back to where this all started. And it starts in Louisiana in 2022. That is where federal law enforcement officers working alongside the ATF executed a search warrant on the home of a man named Timothy Peterson, who also happened to operate a home-based federal firearms license out of that same property. He was not some criminal operating in the shadows. He was a federally licensed firearms dealer operating out of his residence, and during the course of that search, agents discovered a device, specifically what is commonly known as a solvent trap. If you have been in the firearms community for any length of time, you know exactly what that is. And you know that the ATF has been playing games with the definition of suppressor for years, reclassifying items, sending out contradictory determination letters, changing their positions, and then prosecuting people for possessing things that were entirely legal when they purchased them. But in this case, the ATF looked at Peterson's solvent trap and made a decision. They said, that is not a solvent trap. That is a suppressor. That is an unregistered silencer under the National Firearms Act. And because it was not registered, because Peterson had not paid the $200 tax stamp, had not submitted his paperwork, had not gone through the entire NFA approval process that everyone in this community knows is deliberately designed to be burdensome and registry creating, they charged him. They charged him with possession of an unregistered NFA item, a federal felony, a charge that carries up to 10 years in federal prison. 10 years. For a piece of metal that the ATF themselves have given contradictory guidance on for years. For an item that exists in a gray area, the government deliberately keeps gray so they can choose when and whom to prosecute. That is not an accident. That is a feature of this system, not a bug. So Peterson did what any rational person would do when facing a decade in federal prison for something the Constitution should already protect. He fought back. And I want to pause here for just a moment because behind all of this legal theory, there is a real human being, a man with a family, a man who ran a federally licensed business, a man who possessed a piece of metal and is now staring at the possibility of losing years of his life because the government decided to interpret that piece of metal as a regulated item and the courts decided to let them. He moved to dismiss the charge, and his argument was bold and direct. He argued that the National Firearms Act's entire registration and taxation scheme, as it applies to suppressors, is a flat-out violation of the Second Amendment. Not a regulation, not a reasonable restriction, a violation, an infringement. The thing the Constitution explicitly says shall not happen. The district court rejected that motion without engaging seriously with the historical analysis that Bruin demands. They said the NFA has been around since 1934. It has survived challenges before, and it stands. That was the level of constitutional reasoning. A New Deal-era law built on federal overreach gets a free pass simply because it is old and courts have deferred to it for decades. Peterson appealed. The case moved up to the Fifth Circuit Court of Appeals, and at first the Fifth Circuit came out and ruled that suppressors are not protected arms at all under the Second Amendment. Not protected. Case over. NFA wins. But then something happened that almost nobody saw coming. Something that changed the entire trajectory of this litigation. The federal government changed its position. The Trump administration took control of this case and formally acknowledged in a federal filing that suppressors are in fact constitutionally protected arms under the Second Amendment. The same government that was prosecuting Timothy Peterson looked at the Fifth Circuit's ruling and said that is wrong. Suppressors are protected. The Second Amendment applies. That admission was significant. It was a massive shift, and it forced the Fifth Circuit to go back to the drawing board entirely. They withdrew their original opinion. You cannot have the United States government, the party arguing for the constitutionality of the law, admitting that the item in question is constitutionally protected while a court simultaneously says it falls outside Second Amendment protection. The logic collapses. And for a brief moment, there was genuine optimism in the Second Amendment community that when the Fifth Circuit came back with a new ruling, it might actually land on the right side of this question. That optimism did not last long. When the Fifth Circuit issued its new opinion, the NFA survived again. But the reasoning was completely different. And honestly, in many ways, this new reasoning is far more dangerous than simply saying suppressors are not protected, because at least that first argument could be challenged and defeated directly on the merits. The new theory the Fifth Circuit deployed is much more subtle, much more flexible, and much more difficult to dismantle. Here's exactly what they said. The Fifth Circuit assumed, for the sake of their analysis, that suppressors are protected arms under the Second Amendment. They gave Peterson and his legal team that point, and then they still ruled against him. Why? Because they said that even if suppressors receive full Second Amendment protection, the NFA still survives constitutional scrutiny. Their reasoning was that the NFA operates like a shall-issue licensing regime. And under their reading of the Bruin decision, a shall-issue system where the government is required to approve your application if you meet objective criteria on paper is permissible. It does not cross the line into a constitutional violation. Now stop and think very carefully about what that actually means in practice. The NFA requires a $200 tax stamp, federal registration, fingerprinting, photographs, a wait time that in recent years has stretched to many months. Under the Fifth Circuit's reasoning, all of that survives because the approval process has objective criteria and is technically shall issue. And if that logic holds, then ask yourself the obvious question. What stops the government from applying that exact same framework to anything else? What stops them from saying AR-15s are protected arms, sure, but you need a shall issue registration to own one? What stops them from saying standard capacity magazines are constitutionally protected but require a $200 tax and federal approval? What stops them from saying your Glock is a protected arm but you need to submit fingerprints, photographs, wait 6 months, and get explicit government permission before you can take possession of it? Under the Fifth Circuit's framework, the answer is nothing. Nothing at all. As long as the government structures the approval process with objective criteria, as long as they call it shall issue on paper, they can build a tax, a registry, a waiting period, and an approval requirement around any protected arm they want to control. They do not have to ban it, they just have to burden it until practical ownership becomes difficult enough that most people give up. That is not what the Second Amendment was designed to permit. That is not what Bruin was supposed to allow, and that is the framework the Supreme Court allowed to stand today. Here is what happened at the Supreme Court level. When Peterson's legal team filed their petition for certiorari, the formal request asking the Supreme Court to review the Fifth Circuit's ruling, there were warning signs for anyone watching closely. The United States government waived their right to respond to that petition. That is not a minor procedural footnote. When the government waives their response to a cert petition, the Supreme Court itself has the power to step in and order the government to file a full response if there are enough justices seriously interested in the case. They never did that here. This petition moved all the way to conference where the justices privately vote on which cases to accept without any full briefing from the government. Outside organizations, Second Amendment advocacy groups, filed amicus briefs laying out exactly why this issue was critical and why the Fifth Circuit's reasoning was dangerous and needed to be corrected. And still, the court moved forward without demanding that adversarial briefing. That was not a good sign. And now we know the outcome. On today's order list, the Supreme Court officially denied certiorari in United States versus Peterson. They will not hear this case. The Fifth Circuit's ruling stands, and that shall issue framework is now sitting out there in the federal legal landscape, validated and uncontradicted by the nation's highest court. Why did they pass? There are several theories worth examining honestly. The first is the procedural posture argument. The case came to the court without full government briefing, without robust adversarial presentation, and may simply not have been the cleanest vehicle for a major constitutional ruling. There is genuine truth in that. But the Supreme Court does not need the government to respond before granting certiorari. They can demand it themselves. They have done so in far less consequential cases. If 4 justices were prepared to take Peterson, the lack of a government response would not have stopped them. The second theory is the absence of a circuit split. The Supreme Court primarily exists to resolve conflicts between the federal circuits, and right now, no other circuit has issued a directly conflicting ruling on whether the NFA's registration scheme is a permissible shall-issue regime for suppressors. Without that split, there is less institutional pressure to intervene. That explanation also has some merit. But the court takes cases without splits when the constitutional stakes are high enough. And when a federal appeals court creates a new framework that can justify unlimited federal licensing of protected arms, the stakes are more than sufficient. The third theory is that the court is waiting for a better vehicle, a case presenting these questions more cleanly and more broadly through the assault weapons ban challenges or magazine restrictions currently working through the circuits. That is the hopeful interpretation. It deserves to be acknowledged, but hope is not a strategy. While we wait for better vehicles, Timothy Peterson faces federal criminal consequences. While we wait, the ATF continues raiding homes over solvent traps. While we wait, the Fifth Circuit's framework becomes more entrenched and more widely cited with every passing month. The shall-issue framework is portable. Any state legislature that wants to regulate a protected arm without triggering an outright ban challenge now has a blueprint handed to them by the Fifth Circuit and left standing by the Supreme Court. Do not ban the arm. Do not argue it falls outside Second Amendment protection. Build a licensing regime around it. Make it technically shall issue. Put objective criteria on paper and argue that your scheme is constitutionally permissible because it is not a prohibition, just reasonable regulation. That logic migrates. It migrates from suppressors to braced pistols to short-barreled rifles to standard capacity magazines to semi-automatic rifles. Everywhere the gun control movement has been trying to advance for years, and the Supreme Court just signaled today that nobody is standing at the gate to stop that migration. So where does this fight go from here? The cert denial does not settle this constitutional question nationally. Other circuits are not bound by the Fifth Circuit's reasoning. If another circuit addresses this same question and reaches a different conclusion, that circuit split is what eventually makes it nearly impossible for the Supreme Court to keep looking away. And there are already other NFA challenges moving through the federal courts right now, attacking the NFA's tax and registration scheme from different angles, including the taxing power argument, Fifth Amendment grounds, and Commerce Clause challenges. Those cases are still moving. They benefit from knowing exactly what did not work in Peterson, and beyond the courts, there is the legislative path. The NFA is a statute. Congress passed it in 1934, and Congress can amend it. Bills removing suppressors from the NFA have been introduced in multiple sessions. They do not pass because there is not enough sustained constituent pressure making this a real political cost for legislators. That is where this community makes the difference. Call your representatives. Support the organizations doing this legal work. The Second Amendment Foundation, the Firearms Policy Coalition, and others are filing new challenges and building the record that eventually forces the Supreme Court to answer these questions definitively. Here is where we land. The Supreme Court denied cert, the Fifth Circuit's ruling stands, the NFA remains in force, and the shall-issue framework is now embedded in federal appellate law and available for expansion. That is a real and significant setback. But the constitutional question at the heart of all of this is not resolved. It is not settled. It is still working its way through the courts on multiple fronts simultaneously. At some point, the Supreme Court will have to answer it. The only question is when and which case forces their hand. And I want to be clear about something important. A cert denial is not the same as the Supreme Court endorsing the Fifth Circuit's reasoning. They are not saying the Fifth Circuit got it right. They are simply saying they are not going to weigh in right now. But the practical effect of that silence is that a dangerous framework continues to grow and spread without correction. That is why every new case matters. That is why every new circuit that weighs in brings us closer to the moment this court cannot look away any longer. This fight is not over, not even close. The NFA challenge continues. The Second Amendment battle continues on every front simultaneously. And staying informed, staying engaged, and staying loud is not optional for people who care about their rights. It is essential, because the people fighting on the other side are informed. They are organized, they are patient, and they are already studying what the Fifth Circuit handed them today and thinking about how to use it, so stay engaged. Support the organizations doing this work. Make your voice heard in the political process. And never for a single moment accept the idea that the government has the right to make a constitutionally protected right this difficult to exercise. This nation was built by armed scholars, and it will only be maintained by people willing to fight for those rights in courtrooms, in legislatures, and in the public square every single day. Never let anyone tell you that a permission slip is the same as freedom.